taking out light. We are going to do constitutional history, and we are going to discuss the order in council 1902. 1902 order in council. 1902 order in council. We're going to discuss 1902 order in council. We are going to discuss order in council 1902, its implication and why it came there. Put up the topics you want us to. We are trying to sort something here briefly and then we start. Order in council. Oh, Landilo Mayanja Henry. I put up a video for you and I'm putting another video after here. Landilo 1. Commander Linda. Commander, there is that bit. Okay, give us a thumbs up. We are going to start okay, order in council. I don't know if we have second years many on this chat, but be rest assured your videos are going to be put up. Okay, let's do order in council. Order in council 1902. Now, the order in council, the British were trying to order in council 1902. We want to give its implication and also understand this paper. This is what we are discussing, the order in council 1902. Now, order in council came 2 years after the Uganda Agreement. Let me give you a very simple background about order in council. The first background is that when the British came and took over Uganda as a protectorate, when they scrambled and partitioned us to be under the British, to be a protectorate of the British. The British wanted to establish their rule in the protectorate. So they had gotten reports earlier. Remember, Kabaka Mwanga had welcomed the missionaries. They had discovered John Speak the Nile. The H.M. Henry Martin had all come, Stanley had all come to Uganda. Now, at that particular point, they took back a report that Buganda was strategically located. So that is why when the British came to Uganda, the first thing they did was to sign an agreement with Buganda, but that agreement was to establish their rule. Now, they have now formed an agreement. 2 years later, they bring what we call the Order in Council. Now, the Order in Council of 1902, the aim was to consolidate their selves in the protectorate, to consolidate their power, as we are going to see. The reason for the formation of the Order in Council in 1902 was to consolidate their power. They had now they had Buganda on their side, and all they wanted was to ensure that they consolidate their power. So therefore, they borrowed those articles such that they would follow them, everybody else would follow them. But before I even enter into these articles, I want us to first distinguish between Article 1 of Buganda Agreement and Article 1 of the Order in Council. Now, Article 1 of the Buganda Agreement talked about demarcation of the boundaries of Buganda. Colleagues, take note here. In the Buganda Agreement, Article 1 discussed demarcation of the boundaries of Buganda. They wanted to establish Buganda, you stop where? You end where? That was Article 1. But now look at the difference in Order in Council. Order in Council, Article 1, discusses the demarcation of boundaries of the whole Uganda. They are discussing Central Province, Bukedi Region, Buganda itself, Northern Province, Northern Rudolph. You see now, in Order in Council, they have got the whole country, because they are establishing their rule in the country. But for Buganda Agreement, it was only for the Buganda region. So that's the difference. That in Order in Council, they were trying to establish their rule. Okay? Which rule was actually established. Now, when you're answering Order in Council, they will ask you the implications. So like Article 1 of Order in Council, you relate it to Article 177 that creates districts, to Article 179, 178 of the Constitution. So every article you give in the Order in Council, you relate it to the other article, to the articles of the Constitution. Because in simple terms you're saying, is it possible the articles we have in this Constitution, we could have gotten them from the Order in Council? So you look at every article of the Order in Council, and then you find out which article does it look like in our Constitution. Which article does it look like in our Constitution? So, let's go to the next article of the Buganda Agreement of the Order in Council, that there shall be a commissioner who will be representing the Her Majesty's government. A commissioner in Order in Council. And who is the commissioner? It was one who was to control the protectorate. You see now in Order in Council, they have even brought the head. They have introduced the head, because now they are consolidating their rule. They are consolidating their rule. So the commissioner looks like a who in the constitution. The commissioner resembles Article 98 of the Constitution that talks about president. So we are saying it is possible Article 98, we could have copied it from that element of the commissioner being the head of the protectorate. And now we have the president as the head of the protectorate. Three, the other article they said the crown land would be used by the protectorate government. Of course, all government parastatals, schools, hospitals were to be on this crown land. You can now see the difference. That initially, in the Buganda agreement, they said land shall be divided between Mariro and Crown. But now they are saying that land, Crown land is for us. Crown land is now for us. And we shall be using it. Because now they are asserting their rule in the protectorate. You relate that article of land to Article 237 of the Constitution. That it is possible the framers of our Constitution could have gotten the idea of putting land ownership in this Constitution from the Order in Council. It is possible they could have copied from here. Okay. Let's go to the other article of the Order in Council, which is that the commissioner shall be in charge of making laws and collecting taxes revenue for the protectorate. So they have given the commissioner the role of being the parliament. He was the one making laws. So you relate that to Article 79 that creates parliament. Then to also generate revenue or taxes for the protectorate. So the commissioner now is in charge of taxes. You relate that to Article 152 of the Constitution, which forms the taxation, collection of the monies in this country. Then we cross to the other section of the judiciary. They created the Her Majesty's High Court of Uganda, which would be looking into judicial matters. Her Majesty's High Court of Uganda. So this one, thank you. So this one literally, you now link it to Article 129 that forms courts of judicature. Article 129 that forms the courts of judicature. Let's now cross to Article 15 of the Order in Council, which is the reception clause. And then I will end with the Repugnance clause, because I wanted to really discuss the Repugnance clause. The British now, because they are consolidating their rule in the protectorate, they now ask themselves a question. How do we govern these people? They answered it. We need laws. So which laws should we use to govern these people? They decided to bring all the English laws to Uganda, and we received them in what you call the reception clause on 11th August 1902. This was the reception clause, and we received all the English laws in this country. So when you are relating the reception clause to the Constitution, you now say, we received this, but now we have the Penal Code. Of course, among the laws we received included the Penal Code, Judicature Act, Evidence Act, Contracts Act, and many others. So now you say that we received them, that up to now we are still using them. Now you give the new ones we are using, you include, remember, you include the cap. Which cap do we have today? Contracts Act, which cap is it? Evidence Act, which cap? So I've given you research to go and get the new caps that we have. Let's now go to the repugnance clause. This is where I want us to put more energies. Repugnance clause. Colleagues, repugnance clause can be asked as a single, can be asked as an independent question. Repugnance clause. And this is the video that you have to watch or to listen to be able to answer the repugnance clause. Number one, the word repugnance clause means inconsistent. 284, yes, that's correct. Thank you. Thank you. Ronnie Nasumba, thank you. One, the word repugnance first and foremost means inconsistent. It also means incompatibility. To those of you who know English, incompatibility. It means inconsistent or incompatibility. So when we discuss repugnance, we are discussing the African culture. We are discussing our culture. Okay? Now, when the British came, they realized, listen, they realized that the common law was outdated. The common law had outlived its usefulness. But remember, they want to control our culture. They also believe that our culture is ancient. Our culture is barbaric. This is what they believe. They believe our African culture is barbaric. They also believe that our culture is ancient, rudimentary. So they are saying, how do we control this protectorate? How do we control the cultures which are barbaric? They couldn't subject our culture to common law because they believed also common law had outlived its usefulness. So what they did, they set a test by creating the doctrine of morality, consciousness, and natural justice. So when they created this test, the test of morality, consciousness, natural justice, we are discussing repugnance clause if you've just joined us. Now, when they created the test, they now say, for each culture here to be valid, it must pass this test. The test of morality, the test of consciousness, the test of natural justice. That for a culture to be accepted, an African culture must be subjected to these tests. The question is, why did they subject our culture to the common law system? Simply because they also believed their system was ancient. So that's why they formulated the doctrines of morality, consciousness, and natural justice. So, after creating that, colleagues, when they created that, they now started to give us examples of how our cultures were barbaric. So when you look at the cases under here, you must be able to conclude by saying, was it repugnant or it's not repugnant? Let's look at the case of R versus MK. R versus MK. Amkeyo stole a heifer and removed the skin and kept it. The wife Nyadoi had gone to the village. They had just gotten married, and Nyadoi had gone back briefly to the village. When she came back, Amkeyo told her that you take this hide out, but make sure nobody sees it, bring it back. They would sleep on it on their bed. Now, when they found out that he's the one who had it, they took him to court. Now, the point at court was, Amkeyo was telling court, my wife, Nyadoi, cannot give evidence against me because we are married. Listen carefully. Amkeyo is saying, my wife cannot give evidence against me because we are married. It should have been Judge Hamilton told Amkeyo, your wife is going to give evidence against you, simply because what you call marriage in Africa is not marriage, is a mere wife purchase. So Amkeyo is arguing that let my wife not give evidence against me, because by law she's my wife, it is not allowed. Those of you doing criminal, you can now judge. Accessory after the fact for a wife cannot be there. Okay. Now, Hamilton told him, your wife is going to give evidence against you, simply because what you call marriage in Africa is a mere wife purchase. That is one. Two, your marriage involves the bride price. It means you're just buying the woman. That cannot be termed as marriage. Two, a woman is not a contracting party in the process of the marriage. The judge is telling Amkeyo that what you call marriage in Africa is not marriage. First, you ask for bride price. That is purchasing a woman. Two, a woman is not a contracting body because you discuss with the father, not with the woman. Three, a woman is regarded as a chattel, a property. We buy property. You know, you're buying her. So you regard a woman as a chattel. So therefore, what you call marriage is not marriage. And for us, we cannot count that the two of you are married, because your marriage is void ab initio. From the start, you carry a void marriage. So because of that, they allowed the wife to give evidence against the husband, which should not have been the case. Okay? So when they allowed there, are we there? Are we on? Can someone tell me that if we are on? Can someone let me know if we are on? Do you hear me, guys? Can I continue? Can we continue now? Do you hear me? Do you continue? I want to know if you can hear me. Okay, thank you. Now, that is repugnance. Then there's another case of Chirimo being Chirimo versus Chisunda. Now, in Chirimo versus Chisunda, a man called Manga. Now, among the parties, Chiriba versus Chisunda, the person who committed the crime was not there. Now, Manga was a tax collector who got bribes from one of the people and never gave a receipt, or about 10 shillings. When they convicted him, when they took him to court ruled that at the time that his father, Chirimo, was supposed to pay the fine. That a son has committed a crime, and now, because it was their culture in Tanzania, they would now go and get the cows of the father because the son committed the crime. So Chirimo went and reported in the High Court. So we have a case of Chirimo versus Chisunda. Chisunda is the guy who was duped of his money. Now, court ruled that this culture was repugnant. A father cannot be held liable. You cannot seizure the father's property because a son committed a crime. So, it was a culture that was repugnant, that was not accepted, that did not pass the test of consciousness, morality, and natural justice. Okay. So that is what we mean by repugnance. That you look at the cultures, our cultures, that were repugnant with the doctrines of natural justice, with the doctrines of morality, and the doctrines of consciousness. Okay, so that is what we mean by repugnance clause. The question would be, is repugnance clause still existence? Are there cultures which are still repugnant? Yes, they are there. Look at the Mifumi case. I urge you to read the Mifumi case versus Attorney General. Look at the case of the Women for Law Advocacy versus Attorney General. All these repugnant things, the issue of bride price was questioned as being repugnant if you ask for the bride price. In the case of women, we are questioning the issue of female genital mutilation. Look at the case of Best Kemigisha, where they were saying she's a woman, she cannot inherit. All these cases clearly brings out the issue of repugnance, that we don't want to be there. There are those cultures which are barbaric, which are repugnant today to our constitution, to our norms and values in society, depending on the development of technology today. Look at the case of Migade versus Mwenge about customary land. All these are locus classicus case that I urge you to go and read. So that is what they need when they ask you about repugnance clause. Unless there is a question. But we shall end there for today. Until tomorrow. Network has a bit disturbed us, so we can't exceed. I don't know what happened today, but somehow we have been disturbed. So until next time, we thank you. Give us a hands up give us a chigaro, hands up, and like, leave comments, watch our videos, subscribe to Law School Made Easy, subscribe to Voices of the Bar, where the legal world speaks. All those are our channel. Make sure you subscribe to those two channels. You'll get all the information you need. So until next time, we thank you so much. See you.